Hi guys, today we're going to talk about what is a conditional or temporary green card. The 2-year green card. Who gets it? Why? How long is it valid for despite its name? And what does it mean when you get denied for removal of conditions? So first of all, let's start generally talking about permanent residence, right? Permanent residence is given to you through, various situations like asylum or your job, filing for a green card petition, or through marriage. So today we're going to talk about the green card you get through marriage, and it's called conditional or temporary green card when you file for a green card and on the day of your approval for the marriage green card, your marriage is not yet 2 years old. U.S. Congress, in their infinite wisdom, decided that to test whether a marriage was going to stick or not is that 2-year rule. So if you were already married for more than 2 years, 2 years and a day, on the date of your green card interview and approval, that means to them, to the government, that your marriage is likely to stay that way, and you will get a 10-year green card. And your green card will not be conditioned on anything. However, if at the time of your approval, after that marriage green card interview, your marriage is under 2 years, they will give you only a 2-year conditional green card. It is conditioned on your marriage lasting full 2 years after the date of your green card approval. So now, how do you know when to file for removal of conditions? So you're not replacing your 2-year green card with a 10-year green card. You're removing conditions on your permanent residence. And we file Form I-751, petition for removal of conditions. That's usually signed by your U.S. citizen sponsor spouse and by you as the beneficiary, and you are the one who is filing that petition. How do you know when to file, right? So first of all, you look at your conditional green card, and there's a date on it on the bottom that says date became permanent resident. That's the date when you were approved to become a permanent resident. From that date, 2 years is your status as a conditional resident. You count back 90 days. And on the 89th day before the expiration of your 2-year conditional green card, you file the petition I-751. You put it in a package with proofs of your marriage and you mail it away to USCIS. Now let's talk about what it means to file for removal of conditions. At the time of filing, if you're married and living under the same roof with your U.S. citizen sponsor spouse, that means you both should be filling out and signing the form and attaching evidence that you're still living together, that you have proofs that for the past 2 years, even though you could be married at that point for 3.5 years, so in that case, you should be including proofs for 3.5 years of marriage. You've had bills in 2 names. You filed taxes as married filing jointly. Both of your names are in the tax returns, both on the federal and state forms, and you have to provide those. Even better to get IRS transcripts of your joint tax returns and attach them to the actual copies, because the copies of the tax returns show the state forms as well. Bills, utility bills, like electricity, like gas, like some people still have regular phones. Maybe you have a family cell phone plan. Maybe you have credit cards in 2 names and you want to attach statements that show both spouses' activity on that credit card. Your insurance cards, your credit cards and debit cards from the same accounts, put them next to each other and copy them. You get all of that together, plus at least 3 letters from witnesses with their name, address, phone number, and ID copy, explaining how did they know you, give really specific details and dates and specifics about how did they know you being a real couple, and what they can tell you about you as a couple, meaning, what kind of things you do together, where they've seen you. Maybe you went to their Christmas party, maybe you were at the wife's birthday party, maybe you went to dinner together every 2-3 months, maybe you visited them in their home, maybe they visited you in your home, and they could talk about your home, what you do there, where is it, and so on. 3 or more witness letters would be great to attach to all of these joint documents, and you send away. Now, you could get your conditions removed just on paper and just receive a letter saying you're approved. Congratulations, here's your new 10-year green card, right? You file the form I-751. Remember, I said that, not form I-90. You're not replacing a green card. You're removing conditions, and you can get a green card without any interview. And it will take usually around 2.5 years. And it's a long process. Now, if you're not with your spouse at the time of that 1 year and 9 months mark, just 90 days prior to the 2-year removal of conditions date, right? It doesn't mean that you shouldn't file. It doesn't mean that you should just leave and go back home. Not at all. All that means is that you should file based on a waiver of joint filing conditions. So that means you file it alone and you mark off in the category based on your situation, what is the reason the government should make an exception for you and give you the 10-year green card, even though your U.S. citizen spouse is not signing the form and perhaps you already are separated or even divorced. Now, the basis for the waiver are usually that the marriage was real in good faith, but it ended in divorce and basically it wasn't your fault. Or they abused you, like battery, abuse. Similar to the standard for VAWA, if you know about VAWA, Violence Against Men and Women Act. Or maybe it would be a hardship for you if you had to go home and you had to leave your U.S. life behind. So all of those are good reasons to ask for a waiver of joint filing requirement and file it by yourself, but you attach basically the same exact proofs of the marriage. You still have to prove that you were married for quite a while, as close to the 2-year mark as possible, and living together. But also you have to prove the reasons you're asking for the waiver. So if you were abused, for example, you definitely should attach any orders of protection, your divorce, even if you just started it, even if it's not completed. If you were abused, also, we usually ask our clients to, if possible, and if you live in a state that allows this, file for a divorce based on cruel and inhuman treatment, based on abuse. But even if you didn't, just attach the complaint and the copy of the notice of the divorce with an index number on it. Still attach 3-4 witness letters about the fact that you were really married, but also testifying to whatever reasons it is that you're basing your waiver on. If it was in good faith, basically, same thing. You had a real marriage, but you got divorced for whatever reason. If it was abuse, you get, any orders of protection, any arrest records, any psychologist evaluations, anything like that prove your abuse, and usually hardship. Hardship is proved through, again, documents, letters, anything like that. In either case, you don't give up and you file. You don't just say or do nothing and you hide and you hope that something will happen on its own. Nothing will happen on its own. You definitely have to file the I-751 petition to remove conditions, even if you're no longer with your spouse. You just have to fight to make sure you get it yourself based on the waiver, as I said. Now, what happens if your petition to remove conditions is denied? Right? Remember, USCIS cannot take away your permanent resident status by law, okay? Only a judge can. And you're allowed to file one more petition. And I've had many clients who won the second time around. Not the first time, but the second. Sometimes when your petition based on abuse, when you file the loan and ask for a waiver of the joint filing requirements based on abuse, based on battery, if that gets denied, you can still file a VAWA petition. That's a whole different petition, but you're allowed to prove VAWA even if your I-751 was denied. In any scenario, you should get your chance to file again and you should get a chance to go to court and ask for a judge to still give you your green card, even if your I-751 was denied. So remember that this is possible, and get a lawyer if you have a complicated situation. And actually, in today's world of USCIS and immigration, I think everyone should get an attorney, even if you're filing with your spouse, to help you put that package together in such a way that you don't get an interview based on this removal of conditions. You still may get an interview, and that's definitely a place you want to bring a lawyer to, regardless of your situation. So make sure that you hire a competent, knowledgeable attorney. We are certainly very happy to help you. Give us a call. We work with all the 50 states, and we get our clients green cards. We're very interested in a positive outcome and making sure you get that conditional green card, removed conditions, and get your 10-year green card. Give us a call today. We'll be happy to speak to you. All of our consultations are paid, and we have a big team of lawyers who are happy to talk to you, ready to help you. Give us a call today. Please subscribe to our YouTube channel and make sure that you are the first one to see our new videos that we release every week, and you watch our live news every week on Wednesday usually. Have a great day and happy holidays. Bye-bye.